Good morning. Welcome to this extraordinary celebration today. We are just so happy to be able to be here because this is an historic event in the life of our college and our surrounding community. And I welcome everybody from Glen Ellyn, from our college, from the courts. We are so pleased and privileged to have you here this morning. At our college, we believe in student success in all that we do. So to have this place as the place for the first rollout of this exhibit as the partner and higher learning institution for the launch of this is truly exciting, and we are thrilled. Our students are paramount to all that we do, and they are the lifeblood of this college, and we are all about teaching and learning. So this event encapsulates and epitomizes our life every day. Well, it's not every day that we have paralegal, criminal justice, and business law students all in the same room. So we are pleased to have our own students, and we may have some more coming in at 9 o'clock. We have a couple of classes beginning at 9. The faculty came by and said, can we come in late? And our comment was sure. So you may find some more students will walk in here about 9 o'clock. But in the same room now. So we are in the same room as the Illinois Supreme Court Justice Thomas. It's very, very nice to have you here today. We're grateful to you for taking out time of your busy schedule, because these are always busy times, and your graciousness to also answer some questions and be with us today. Just very, very privileged. We're also so pleased to have our chairman of our Board of Trustees, Deanne Mazzocchi. Very, very nice to have you here too today. So this is about education and enlightenment, and it's just a great day. So I want to thank everybody here for having an interest in this on a Friday, having an interest in this during our Constitution Week, and to have an interest in this for the sake of just a pure grasp of knowledge. And so I would like to thank each and every one of you for being here, to our faculty and our staff and our leaders around the district for supporting the College of DuPage as your community college. I would now like to introduce the chairman of the Regional Transit Authority, Mr. Kirk Dillard.
Thank you, Madam President, and good morning. So you suppose, why is the chairman of the Regional Transportation Authority up here? It's because I have the honor of wearing a couple of hats for today. Number one, I'm proudly a longtime member of the College of DuPage Foundation Board, and this institution is very special. I'm a DuPage County resident, and it is a very special place for this county and for this region. But I also serve very proudly on the Illinois Supreme Court's Historic Preservation Commission. And when you see this exhibit today, I've seen firsthand the work of not only the justices, but especially John Lupton, who is a member, or who really heads up as our chief staff at the Illinois Historic Preservation Agency. John's here with his family today. But behind the scenes, John, with very limited resources, as Justice Thomas will tell you, has just done a spectacular job of taking the history. And I told some of my former colleagues from the legislature, remember, there are 3 branches of government, and the judiciary is an equal branch of government, and sometimes it doesn't get the publicity that the executive branch with the governor's debate last night might get, or our local legislators. Let me just close by saying thank you for being here. This is really important. It's a historic time for our state. And in my life, both as a lawyer, and I had 2, Justice Thomas and Justice Rafji, I had 2 Supreme Court justices teach me in law school. Justice Bill Clark and Justice Dan Ward I had as professors. So I got to see the dedication of the members of the court, not only as jurists, but also as teachers. And then I've been very blessed to have friends like Justice Joe Burkett, Bob Thomas, and Louis Raffji. And in Bob Thomas and Louis Raffji, we have had two of the finest and most ethical members that the Illinois Supreme Court has ever seen in its history. And the public should take solace in the fact that these not only are brilliant men and lawyers and judges, but they're good people. And I think that is a trait of a justice, whether you're an appellate justice like Joe Burkett, a Supreme Court justice like Louis Raffji, and you're always my former Chief Justice, Mr. Thomas. We have good people from our particular area and on the Supreme Court. So thanks for being here. This is really important. And again, John, to you and to the folks at the Historic Preservation Commission of the Supreme Court. Justice Ann Burke is also very much instrumental in that. And Justice Thomas, thank you for carrying the ball for the court as you do and for our justice system every day. So it's my honor to be here, and thank you very much.
Thank you, Senator Dillard, for those comments, and in particular for your recognition of the fine service that we all benefit from with the people in this room today. And good morning, everyone. My name is John Ness, and I'm the General Counsel here at College of DuPage. It is a great honor to be here today at the launch of the traveling Bicentennial of Illinois Law exhibit and to commemorate the 200th anniversary of the judiciary of the state of Illinois. I'd like to take a moment first to recognize the large number of dignitaries who are here with us this morning, including members of our judiciary, as Senator Dillard noted, elected officials, and members of our college's Board of Trustees. I'm not going to try to name all the names here, but I am going to ask that if you would like, and as you are able, please stand and be recognized if you're a public official. Thank you. Today we are here to celebrate an exhibition that concerns the judiciary of Illinois. It is a remarkable fact that our judiciary in this state has been unified. It's been a unified court system for 200 years. In fact, the first constitution of the state of Illinois, which was passed, I think, on August 26, 1818 in Kaskaskia, Illinois, created the Supreme Court, and it also gave, I should say, the power to the legislature to create other courts that it would from time to time ordain and establish. Obviously, the legislature did ordain and establish other courts. Those include our circuit courts, our trial-level courts. We have our own trial-level court here, the Circuit Court of the 18th Judicial Circuit in DuPage County, and we also have our unified appellate court system. And that hears the intermediate appeals of cases that come from the circuit court. Together, these three levels of the judicial branch hear thousands of cases per year and enable the citizens of our state to obtain a resolution of their disputes. Now, sometimes half of those resolutions are not to the liking of the litigants, but we're not here to talk about that. We are here to talk about the resolution of cases and peaceful resolution of cases and just resolution of cases. And the exhibit that we're here today to open reflects and illuminates the legacy of the courts of Illinois. And think about that. For 200 years, we've had a unified court system in this state. There are nation states that cannot boast of that accomplishment. That is something that we should all be grateful for and proud of. Now, as a Center for Educational and Cultural Excellence, we at the College of DuPage are enormously excited to be a part of this unique bicentennial experience about the judiciary in Illinois. And we greatly appreciate the hard work and support of all of you who made this exhibit possible. You have our sincere and our deep gratitude. By serving as the inaugural host of the traveling bicentennial exhibit, the college can help our community, all of us, to come together to learn about and further appreciate the essential service provided by the courts of our state. What's particularly exciting about this exhibit is it provides a wonderful opportunity for students to discover the traditions of our state's courts, especially our Supreme Court, and all the people who have shaped it and the cases that have influenced all of us. Through learning opportunities like this exhibit, our students' enthusiasm for learning is stoked, and their knowledge and curiosity about the larger world and about matters of law and governance in general is greatly enhanced. Your presence here today demonstrates your support and your encouragement for the people who will lead us in the future. And to that we say thank you. And now, it is our great honor to welcome today's very special guest, Justice Robert Thomas of the Supreme Court of Illinois. There really is no one better suited to speak about the Illinois judiciary than Justice Thomas. A graduate of the University of Notre Dame and our own Loyola University Chicago School of Law, Justice Thomas was first elected to the bench of the Circuit Court in DuPage County in 1988. In that capacity, then Judge Thomas presided over civil jury trials and eventually served as the acting chief judge of the circuit from 1989 to 1994. In that year, 1994, Judge Thomas became Justice Thomas when he was elected to the Illinois Appellate Court in the 2nd District. And then, on December 4, 2000, Justice Thomas was sworn in as the Illinois Supreme Court Justice for the 2nd Appellate District, and he continues to serve in that role to this day. And we are grateful for that service. Justice Thomas served as the Chief Justice of the Court from September 6, 2005 until September 5 of 2008. Justice Thomas is a member of the Academic All-American Hall of Fame, and in January of 1999, he received the prestigious NCAA Silver Anniversary Award. You might ask why the NCAA is involved in this. Well, as I'm sure many of you know, Justice Thomas had an interesting career before he came to law. And as I mentioned to him this morning, I, as a younger person, was the beneficiary of an autograph from Justice Thomas. And that was a highlight in my young life. And so, no stranger to DuPage County, of course. Justice Thomas is also a member of our fine DuPage County Bar Association. So, with that introduction, I'd like to welcome you, Justice Thomas, and thank you for your presence here today.
Well, when he introduced me, he said, as a younger person, when he told me that story about the autograph, he said, as a young little boy. So I feel a little bit old as I stand here. There is no truth to the rumor that I was around 200 years ago when we started this whole thing. I am the senior justice on the court, but I'm actually the second youngest justice on the court. It's just longevity on the court that determines that. So, but it is great to be here. Good morning. It's an honor for me to be here this morning for the opening of the Bicentennial of the Illinois Judicial Branch. I would like to thank the Supreme Court Historic Preservation Commission for all the work it has put into preparing for this day, and I'd like to thank the College of DuPage for its willingness to serve as the exhibit's first host. I consider it both an honor and privilege that this exhibition of scholarship and history begins its journey across the state in my home district, in my hometown. And at the risk of getting in over my head, I would like to take a few minutes to offer my own perspective on the history of the Illinois courts. And that perspective is rooted in an opportunity I had a few years ago to do a bit of my own historical research at the request of the Illinois Bar Foundation. The occasion was an event to raise funds for the placement of a monument on the grave of Samuel Treat, the first Illinois Supreme Court Chief Justice to serve under the Illinois Constitution of 1848. And I was invited to say a few remarks at the fundraiser, which caused me some amount of stress because, to be honest, I had never heard of Justice Treat. But I accepted the invitation, and I'm glad I did, because I came to learn a great deal about a remarkable man, a wise and able jurist, a devoted man of God, a trusted friend of Lincoln. Now, make no mistake, the Illinois Supreme Court has certainly changed since its membership included Samuel Treat. Today, the Supreme Court's docket is dominated by weighty and consequential questions having broad policy implications: sentencing reform, due process of law, privacy rights, equal protection. In Justice Treat's time, the court's docket was much more parochial. It must be remembered that at this point, Illinois did not have an intermediate appellate court as it does today. Consequently, every appeal was taken directly to the Illinois Supreme Court. The result, am I doing that? I'm doing something with this computer here, so if we're changing photos, it has nothing to do with the talk. So, the result was a docket defined by largely private disputes. The actions were for trespass, debt collection, breach of contract, the recovery of converted property, And the parties involved were neighbors, former business partners, and tradespeople, which is not to say that Justice Treat was not also called upon to decide the big question. In 1853, Justice Treat authored a decision that declared an act of the General Assembly invalid under the Illinois Constitution. The case was Spengler versus Jacoby. Jacoby, it seems, was served with a summons to appear before the McDonough County Circuit Court. He moved to quash the summons, arguing the statute fixing the term for the McDonough County Circuit Court was not lawfully enacted. As it does today, the Illinois Constitution then provided that no bill may become law without a majority vote, and that all final votes must be recorded in the legislative journal. As it turns out, the bill fixing the terms for the McDonough County Circuit Court was signed by the presiding officers of the House and Senate, sent to the executive for signature, and signed into law by governor. Unfortunately, the final vote of the House of Representatives was never recorded. According to Chief Justice Treat, without such recording, quote, it does not appear that it passed with the concurrence of a majority of the members of that body. Accordingly, Justice Treat continued, the act did not become a law in pursuance of the provisions of the Constitution and is therefore null and void. Although it's not unusual today for the Illinois Supreme Court to invalidate an act of the legislature under the Illinois Constitution, it was extraordinary in Justice Treat's time when the doctrine of judicial review was still relatively young and somewhat controversial. This was not a decision made lightly, and I'm certain it required some measure of courage. And just a few years before that, in Thornton's case, Justice Treat was called upon to assess the constitutionality of the Illinois fugitive slave law. Hampstead Thornton, a fugitive slave from Missouri, was arrested and taken into custody by the Sangamon County Constable who was acting under authority of Illinois law. Thornton appealed his arrest to the Illinois Supreme Court, arguing that the Illinois law was unenforceable because only the United States Congress had the power to regulate the capture and return of fugitive slaves. Writing for a unanimous court, Chief Justice Treat agreed with Thornton's argument. He declared the Illinois law void and ordered Thornton's immediate release from custody. Although essentially a preemption case, that is a case involving the state's power to legislate in an area already governed by federal law, Thornton's case was also a slavery case. And in addressing the state's right to decide for itself matters relating to slavery, it foreshadowed the coming conflict that would first define the Lincoln-Douglas debates and later divide and forever change the nation. But Thornton's case was the exception. By a wide margin, the vast majority of cases to come before Justice Treat were, from history's standpoint, unremarkable. But this did not mean that Justice Treat's decisions were not consequential. On the contrary, every decision that Justice Treat rendered, whether it freed a fugitive slave or simply restored a plow to its rightful owner, made a difference in the lives of the people involved. When I was sworn in as Chief Justice of the Illinois Supreme Court in 2005, I asked both the bench and bar to remember that at the heart of every case is a human being, a person for whom this particular case means everything. And I ask that amidst the debate and discussion of important policy questions, the writing and revising of opinions and dissents, we never lose sight of the very real people whose extraordinary problems lie at the heart of what we do. I'm confident that Justice Treat, serving almost 2 centuries ago, was never in danger of losing sight of the people at the heart of his cases. His cases were defined by the people involved, many of whom were Justice Treat's neighbors and acquaintances. In a way that it no longer can be, the Illinois Supreme Court was in Justice Treat's day a court of the people, where the disputes that define our day-to-day lives were settled swiftly and with little notice or fanfare. Today, the issues are far more complex, the parties are often remote, and the attorneys practicing before us unfamiliar. But that does not mean that we as judges should lose sight of what is at stake. Every day in courtrooms from DuPage County to Alexander County, Decisions are rendered that will never be published, will never make headlines, and will never be reviewed by the Illinois Supreme Court. But these decisions are important nonetheless, for they, as much as any decision rendered by the Illinois Supreme Court, affect the lives of real people. So yes, exhibits like this are important, and I invite all of you to spend some intentional time surveying the course of the law's development in Illinois. This exhibit reminds us that we are the beneficiaries of the great lawyers and the great judges who came before us and to whom we owe a tremendous debt. At the same time, it reminds us that every day we are building a legacy of our own, one that will influence and shape generations of lawyers and judges to come. My prayer is the work I do and the work all of you do will leave a legacy worthy of remembering a century from now. Thank you and God bless.
Thank you, Justice Thomas, for those very insightful and educational remarks. I was particularly interested to hear the story of both the Spangler and the Thornton cases, and to hear the great similarities between the Spangler case and the famous Marbury versus Madison case out of the United States Supreme Court, which, as many of us know, was the first case in the U.S. Supreme Court to establish the doctrine of judicial review of acts of Congress. So it was fascinating to hear that, and thank you for that speech. Today we have at our...
It's great to see you've grown up, by the way.
That was some time, wasn't it, Justice? Yeah. That's a true story. But obviously, the College of DuPage is an institution of learning, and we have some wonderful students here. We do not have a College of Law, which probably makes some people happy. But we do have a wonderful paralegal program. We have a wonderful criminal justice program. We have business law students here. That program is terrific. And I know that we have some paralegal students here today who I'm sure are thrilled to have you and all of our guests here today. We have members of our paralegal program, and we wondered if you would indulge us with a few questions.
Sure.
And one of our questions we have is from one of our paralegal students, Kayla Adams. Is Kayla here today? Kayla, would you?
So my question is, how do you keep your feelings and opinions separate from the law when deciding and hearing different cases?
That's a great question, Kayla, and I think that it's a question that should be answered often. You know, we live in divided times, right? And people have, it seems to be, if you watch the news, opinions on everything. And if you flip channels, you can hear the converse opinion on any subject and any topic. And judges as well. I mean, we don't live in a vacuum. We do have our own beliefs and thoughts, but I think that the reason it's a question that deserves to be asked and answered often, I think there's a fundamental problem with how people view the judiciary, because it's so different than every other area of government, right? Other areas of government indicate, hey, this is what my belief is, this is how I'll vote, and voters who agree with that position will presumably vote for them. Mm-hmm. But with the judiciary, it all starts with the law. It isn't a situation where we take an oath not to be predisposed on cases. So we don't figure out the result we want and then figure out how we make the law achieve that result. We have a case before us, you know, there's facts before us. We start with the law, we apply the law to those facts to achieve a just result. So that's pretty much the answer to that question. You know, number one, our oath not to be predisposed regardless of our own beliefs, and to know that the analysis of our cases starts and ends with the law.
Thank you.
Sure.
Thank you, Justice Thomas.
Thanks.
Thank you for that wonderful question. That is a question that I think gets asked a lot of judges and justices, and thank you for imparting your wisdom on that. Our second question is from Kristen Oakley. Is Kristen here?
Good morning. So I have to say, I wrote this question for you, kind of coming from my 16-year-old daughter who's trying to decide what she wants to do in college, which currently is an FBI agent. That's what she wants. So I was wondering what kinds of things you were interested in as a child and as a teen, and then how did that develop into becoming a justice?
I would tell your daughter to start kicking footballs.
She does play soccer.
Hopefully
so-
make it to the NFL. Run for judge and get the most votes. No, there is, I'm obviously kidding, but when I ran for judge the first time, I realized that, having been on the front page of the paper for either winning or losing games, that there was a certain perspective that came out of that was helpful for being a judge, right? That I'd never been in a profession in which, my profession as a judge is kind of overshadowed a little bit still, even at my age, by playing for the Chicago Bears. I was in a supermarket the other day. I'm going to get to the answer to your daughter's question. My wife said I do 20 minutes when the refrigerator light goes on. But I did. This actually happened. I was in a supermarket, and a guy comes up to me, and we were in the cereal aisle, by the way, and he's looking at me, and I'm looking at him, and he said, "Can I ask you a question?" And I said, "Yeah, go ahead." He said, "Didn't you used to be Bob Thomas?" I said, "Yeah." I used to be Bob Thomas. But I think I had my moment in the sun. We have judges here, great judges, Louis Rathje, Joe Burkett. I don't know if any others are here. I think the danger when you become a judge and put on the robes, you think you're something powerful, and it's the robes. The fabric of the robes is really made out of, hopefully, humility and responsibility rather than power. And I think there's a tendency when everybody laughs at your jokes because you're a judge or opens the door for you because you're a judge, you start thinking that you're kind of important. And I think the fact that I had already had that helped me gain that perspective, hopefully, of humility and responsibility. But back to your question, I was like anybody else growing up. I don't think that I was a soccer player. I played football. There's some truth to that answer. By the time I got to college, I knew that the law is what I wanted to go into. Before then, I wasn't sure. I was a government major at Notre Dame. I got out and practiced law. I thought the reason that I think I gravitated to the judiciary, it's a pretty good job when your job responsibility is to be fair. So I would say that, like in any profession, I would just tell your daughter, pick something that she really loves and wants to do for the rest of her life, and then pursue that with all her heart, and hopefully good things will happen. Thanks.
Thank you.
Thank you for that wonderful question as well. And I know that we probably have some anxious people out here who want to get to look at the exhibit, and they want to see our ribbon cutting. They want to get to the food. So I will move things along. If you would indulge one more question. Sure. We've been talking here today about the 200-year history of the Illinois Judiciary, and there's a rich history there, as you outlined. And you touched on this a little bit, I think, in your speech about how the practice before the court and how the work of the court has changed over 200 years. It's less personal, perhaps weightier issues, the development of the doctrine of judicial review of acts of the legislature. As we look at the last 200 years, and we look at the to use an overused phrase, the arc of history going forward, what do you see as some of the greatest challenges and opportunities for the Illinois Supreme Court in the next 200 years?
Yeah, I think some of those challenges and opportunities have already presented themselves. When I was chief, we put a professionalism commission. The Supreme Court has a professionalism commission now, one of 13 or 14 states that I think has that, to try to make civility the norm among attorneys in Illinois. I think we're succeeding in that regard, and I believe that is something that 200 years from now will be as important as it is today. But I think both the challenge and the opportunity, the major one, as I think about it, will come in the form of technology, I think. The Illinois Supreme Court now has instituted e-filing, which, by the way, is a real challenge since we don't have a unified court system in the sense of, one fund to take care of that, but we're proceeding along those lines. But I think more importantly than e-filing, the cases that'll start coming before the court that really are even hard to envision right now because technology is changing so quickly, cyber crime, for example, or those type of things that Samuel Treat certainly wouldn't have contemplated. And we're going to have to find ways to handle that. But I think our court has made a priority on access to justice. And access to justice is, justice has to be fair and accessible to both the rich and the poor alike, right? And I think that is an effort that we're promoting right now, and I think that's where technology may start to help, right? With, I mentioned e-filing, but different ways of being able to have everybody get their case heard as a result of some of this technology. So I see technology as both the hope and the challenge of the future.
Thank you. That's very helpful. And thank you again for your presence here and for your wonderful comments. And thank you again to everybody for coming to this event. I believe now that we are considering the ribbon cutting. Is that right? So are we adjourned to the hallway? Okay. Thank you all. And please join me in a round for Justice Thomas.
Thank you. Thanks, John.
Thank you,
It was
sir.
fun.
It was fun. Thank you very much.
Yeah, sure.